So yes, today we're gonna make kind of summary of 2 years of practice of inspection proceedings before the UPC. Sorry. No, sorry. No. Okay, it's okay. Okay, so the UPC was designed to combine the best and the most efficient features of the main EU national patent litigation systems. So it logically includes the possibility to request and perform infringement seizure, so the so-called saisie contrefaçon, or orders to preserve evidence. The concept of unannounced inspection proceedings is already well known and practiced in several UPC members, but the unannounced saisies is quite specific to very few countries such as France, Italy, and Belgium. So after 2 years of practice before the UPC, we will see which approach was chosen by the UPC judges, and more generally, we will take stock of those 2 years of practice. So first, some figures. As you can see, during the first 2 years of the UPC, only 18 cases have involved a saisie request. So if we look at the figures in the June 2025, and if we considered only the case including infringements, so there were about 350 cases case of infringements. And so, as I said, only 18 cases involved a saisie request, which it's not that much, even if it's increasing month after month. If we look at the countries where the where the seizure were performed, so unsurprisingly, the majority were performed within the countries who are quite familiar with the seizure, so mainly in Italy, in France, in Belgium, but we can see that it has already started spreading to other divisions and jurisdictions such as Munich, Copenhagen, and Lag division. So we will go through the key points on the condition for obtaining and enforcing a seizure order, and we will see how the UPC judges interpreted it and motivated their decision. So just firstly, at a glance, how inspection proceedings are working. So an applicant that suspects infringement is allowed to request the judge to carry out a preservation of evidence procedure before the division competent to reach the main action. By default, it's an important point, we will revert to it later on. By default, the holder and the inspection proceedings are inter partes, which mean that the court has to summon the allegedly infringing party, and by principle, it should lead to a contradictory debate. However, the applicant has the possibility to request an ex parte decision, but it has to demonstrate to the court that informing the opposing party could cause irreparable harm and/or lead to the destruction of evidence. Then the court issues an order appointing an expert. He allowed the applicant so to perform the saisies in various places, in various relevant places, head office of the alleged infringer or premises, and so, etc., etc. And after the performance of the saisi, the writ of summons shall be served on the defendants within 30 days from its service. So now reverting to the key point, the main issues regarding inspection proceedings. So the first issue is ex parte versus inter parte. So as I said, it's by principle the inspection proceedings are inter partes, but that's a crucial point because for practitioners such as French or Italian or Belgian, the main interest of the infringement seizure is the surprise effect. So if the defendant is aware that a seizure will be performed, it lacks of efficiency. So let's see, here are some figures, and let's see if in practice which approach was chosen by the UPC judge. So we can see that in the majority of the case, so 14 cases out of 18 cases, the orders have been granted ex parte. So obviously, as I said, the two main conditions are to be fulfilled, alternatively or cumulatively. So here are some example of example of the decision that's already been rendered. So the EPCO considers irreparable harm mainly when the situation requires immediate action. So as an example, because of the length of proceedings, so if the alleged infringement is temporary, the delay of a full hearing may render protection meaningless, or if the infringer is outside the EU, obviously urgency increases when the infringer is established abroad, so they could leave the EU with the infringing goods, preventing enforcement. Okay, another ground is where there is an intensive marketing in a small and highly competitive market creates an urgent risk of irreparable harms. So as for the second condition, so the risk of evidence loss, several recurring arguments support this finding of risk of evidence loss. So it seems obvious when we are in presence of digital evidence, because electronic data can easily be hidden, altered, or deleted, or where there is a prior conflicts or lack of cooperation of the alleged infringer, so a defendant who refused to respond or cooperate, raise suspicions. Another case, possible case, is the mobility of the products. The easier the products are to move, the higher the risk of disappearance. So, as I said, to obtain an ex parte order, you have to show and to bring a demonstration. Otherwise, the ex parte inspection order are not granted, and there are some examples where the ex parte inspection proceedings were not granted when there is a lack of sufficient evidence or insufficient proof of likely infringement, or if the products are constantly available on the market, there is less risk that they will be removed, or in the case where there is a need for extended testing, so when infringement can only be proven after long-term testing. Yes, for example, Hinnemans. So, as I said, in the majority of the cases, ex parte orders were granted. Another important issue is the question of the proportionality and balance of interest assessment. So in the majority of the case, the court performed this balance of interest. So between granting the inspection orders versus considering the defendant's exposure or interest. So here are some examples from the UPC decision. So in some cases, the court stressed that the defendant's business was not likely to be substantially affected by the saisy. And on the other hand, in example, before the Milan division, only granted some of the measures requested to limit the scope of the saisy. And I have to say that, for instance, in France, even if it's not required by law, the judges are always using the balance of interest and proportionality assessment. And today, in the majority of the cases, they are limiting the scope of the saisy with regard to this assessment. Another interesting point is whether the UPC judge shall consider the validity of the patent to assess whether they should grant an inspection order. It's not required by law, but they are doing so definitely, and it's kind of part of the proportionality assessment. So focusing now on attendees to perform the saisy. So the UPC rules leave some discretion to applicants and judges regarding the team in charge of performing the saisy. And the rules say that it shall be in accordance with the national law. And we can see that in most cases, the person chosen to be in charge of performing the saisy was a patent attorney assisted by a bailiff. The saisy report shall be provided to the court within a very short time. And the UPC judges considered that 1 day, 2 days, 7 days, 10 days, or 2 weeks were kind of very short time according to the UPC rules. Only one case in which the deadline to file the saisy report was significantly longer for 3 months, which can be explained by tests that possibly needed to be performed by the expert on the sales accused product, so after the seizure. Another important issue is the question of the access to the seizure report and protection of confidential information. Obviously, the applicant who is performing and conducting the saisy want to have access to the seized documents and materials, but if very often, obviously, the documents can be considered are confidential or are protected by the business secrets. So at any time, the plaintiff can request the documents to a limitation to the access of the documents, and we can see that the majority of the saisy orders issued include provision allowing the saisy report to be made available to the plaintiff's attorneys at law under a strict confidentiality regime, so the so-called confidential club. As for the question of the security deposits, it's up to the applicant to do so when it's ordered by the UPC judge, and we can see that in the most cases it's it's ranging from 7 to 75k euros, and we can mention that in extremely urgent cases, in particular in the context of trade fairs, the court may order that security be provided, but allow it to be filed after the execution of the saisy, or even determine that no security is required. So, in conclusion, the 2 years of practice confirmed that saisies are very effective tools for gathering evidence, but even so the number is increasing month by month. They still represent only a small fraction of the cases before the UPC, but there is no doubt that their number will continue to rise in the years ahead. Thank you very much.